Just a minute. How about the defendants?
They are absent, my lord.
Appearances. Who is the lawyer for Engineer Task case? Engineer Tan, the Kogi State Community and Social Development.
My lord, are you the
one? Sorry?
My lord, we are for the plaintiff.
You are for the claimants.
The claimant, sorry, my lord.
What's your name? You are supposed to have joined. Didn't you give her the
E.A. Olorumaye Esquire.
E.A.
Olorumaye.
Does your Maye has an I?
D.A. Olorumaye Esquire, my lord.
Your Maye, does it has an I or just M-A-Y-E?
My lord.
Please go back and close the door.
Yes, my lord.
Does it has an I or just
M-A-I-Y-E?
M-A-I-Y-E or just M-A-Y-E?
Yes, my lord. Olorumaye.
For the claimants.
For the claimants.
Any other appearance?
Claimants, my lord.
Any other appearance?
No any other appearance, my lord.
There is physically in court here in Abuja. What's your name? Learned Counsel. Nihi N-I-I-M-A. Oh, there's a legal officer here standing in for the defendant.
Yes, my lord.
Here is the judgment of the court.
Yes, my lord.
By a general form of complaint dated 16th of December 2019, claimants pray this court for the grant of the following reliefs against the defendant. 1, a declaration that the termination of a contract of appointment of a claimant was not in accordance with due process. Mute that system, mute it. B, the sum of 7,120,000 naira. And in the alternative, which is relief C, the sum of 8,800,000 naira each. Filed in support of the above is a 16-paragraph statement of facts wherein claimants averred that they were staff of the defendant at their head office in Lokoja. The first claimant was a monitoring and evaluation manager, while the second claimant was finance and administration manager. They stated further that they were given the authority to operate the government contribution account of the defendant, which was there to have a statutory board. And by the time the board was inaugurated in October 2017, they had operated the defendant's account for the purpose of carrying urgent operation of the agency in accordance with the defendant's budget as approved by the World Bank. This was later identified by General through an audit exercise in May 2018, where it alleged an unsubstantiated misappropriation against the claimants. The claimants continued that even though nothing incriminating was found against them, they were suspended by the SSG, that is the Secretary to the State Government, and the board thereof. Their employment were later terminated due to the World Bank's intervention v. the claimant's appeal, the defendant's board rescinded their retrospective termination of their appointment and accepted to pay their terminal benefit. The claimant contended that the termination of the appointment was not in line with the staff regulation and condition of service of the defendant, as they were not given fair hearing. In response, the defendant filed a 16-paragraph statement of defense where it admitted that the defendant was a former employer of the claimants. It denied the claimant's claim that the first claimant was appointed as acting general manager of the defendant. It contended that the enabling statute is the Kogi State Agency for Community and Social Development Project, also known as KGCSDP, SDP Law 2009 and Law 2008 as claimed by the claimants. The defendant averred that the claimant expended the defendant fund without due authorization, whereof the investigation carried out by the Auditor General of the State revealed that the claimants grossly misappropriated the sum of 99,154,783 naira 49 kobo in that regard. Query letters were issued by the Accountant General of Kogi State to the claimants in order for them to explain themselves, but no satisfactory reply was received from them. The board of the defendants met and resolved to suspend the claimants owing to their unsatisfactory reply to the said query. The defendant averred further that the claimant's appeal to the World Bank was a breach of the agency's internal grievance resolution mechanisms, and that contrary to the claimant's claim in the appeal, the World Bank reply merely asked for clarification of the position of the board, and after perusing the issues surrounding the suspension and termination of the claimant's appointment, they were satisfied and concurred to the action of the board, and no objection was received to that effect. They only considered to pay the claimant's terminal benefits in view of the fact that the investigation of the allegations against them ended in termination of appointment and no dismissal. It further averred that the indefinite suspension and eventual termination of appointment of the claimants was proper and in accordance with the Staff Regulation and Condition of Service 2019, which, however, only entitled them to terminal benefits. By the approval of the World Bank has since then been paid to them. The order is called to dismiss the claimant's claim in its entirety with substantial cost. Parties in this suit consented to and adopted the argument on record procedure pursuant to Elder 38, Rule 33 of the Rules of this Court 2017. It's consequent upon this that the claimant filed and adopted their final written addresses. The sole issue was captured, which it's in the body of the judgment. The defendants equally filed their final written address, and I've captured that also in the body of the judgment. I'll go straight to the decision of the court. I've perused the originating processes in this case together with the statement of defense of the defendants, testimonies of witnesses before the court, and all the relevant exhibits tendered, and I find from the issues framed by the parties that the sole issue that will meet the justice of this suit is whether or not the claimants have proven their case against the defendant to be entitled to the relief sought. Let me at this stage address the way and manner Learned Counsel for the claimant cited a particular case in this court. Learned Counsel for the claimant in this case relied on and quoted the case of John Oforiche and Nigeria Gas Company Limited, SC/175/2006, which as cited is an unreported case. Learned Counsel has a duty to furnish the court with a certified true copy of the judgment since it is an unreported case. The Apex Court held thus in the case of Chidoke and another versus First City Finance Limited citation captured those, and I quote, "A counsel who wants the court to make use of the authorities cited must provide and cite the cases with clarity, that is, the name of the parties, the year the case was delivered. If it is unreported, a certified true copy. Where the case has been reported, the name of the law report, the year, volume, and the page. To dump authorities on the court without clear reference, that would not be accepted by this court. Cases are decided on the facts presented in court and form the basis of the court's decision. Where the facts of the case are not known, the court will not be in the right position to know how the decisions were reached," unquote. See also the decision of the Apex Court, per Amina GSC, in the case of Oni and others versus Governor of Ekiti State and another. Citation is provided where her ladyship aptly captured it does, and I quote, "It is an elementary principle, very elementary, that counsel who wants the court to make use of the authorities cited in court must provide the name of parties, the year the case was decided, and where the case is reported, name of the law report, the year, volume, and page must be cited. But if the said case is unreported, counsel must provide the court with a certified true copy of the judgment sought to be relied upon," unquote. It is on the authority of both cited decision of the Apex Court, and I find that the unreported authority cited by learned counsel for the claimant without furnishing the court with a certified true copy of the judgment is not useful to the court. Therefore, the court cannot rely on SAPE. It is thus discountenanced. Next is to the cross of this case. The claimants in the suit averred that they were staff of the defendant until the termination of their contract of employment and sought the grant of declaratory reliefs that the termination of the employment was not in accordance with the due process. I am aware that declaratory relief is essentially a remedy for a justiciable controversy. It's an equitable remedy in that it may not always be offered if the situation does not warrant it. Declaratory relief refers to a court's judgment stating the right of parties without ordering any specific action or listing awards for damages. When a party is requesting a declaratory judgment, the party is seeking an official declaration regarding the status of a controversy in issue. It is strict law that in a claim for declaratory relief, as in the instant case, the claimant must succeed on the strength of their own case and not on the weakness of the defendant's case. That is, claimant will not be entitled to judgment even on admission of the defendant. See the cases of MTN versus Corporate Communications Investment Limited citation captured. The case of Oni and Governor of Ekiti State and other citation is equally captured. The case of Uyutola and Adeleke and other citation is provided. It is the duty of the claimant to first prove the existence or non-existence of what he or she asserts by relevant, admissible, and credible evidence. Once this burden is so placed on the claimant is discharged, the onus then shift to the defendant. So the case of Uzodima and Ihedioa citation is provided. The Supreme Court in the case of Chief Godwin Onemu and others versus Commissioner for Agric and Natural Resources, Asaba, and 4 others, citation provided, held us, and I quote, "A party should plead all the facts and all the documents he intends to rely on at the trial of the case. During that trial, he should establish by evidence, oral or documentary, those facts on which his case rests and depends on," quote. Claimants hearing pleaded that the defendant is a statutory agency of the government and also a creation of Kogi State Agency for Community and Social Development Law 2008. In response, the defendant averred that its enabling status is a Kogi State Agency for Community and Social Development Project Law 2009 and not 2008 as claimed by the claimants. I've gone through the evidence in this case, and I can categorically say that the enabling law which the claimant themselves punished the court with is titled, quote unquote, Kogi State Agency for Community and Social Development Project Law 2009. It seems to me that the claimant merely made a typographical error in their pleadings as to the date of the said law. As rightly pleaded by the defendant, the law is dated 2009 and not 2008. The law is now settled that there are different categories of employment relationship. There are 3 categories of contract of employment as follows. 1, purely master and servant. 2, servant who hold their office at the pleasure of the employer. C, employment with statutory flavor. See the case of Controller General of Customs and Gazelle citation capture, the case of Ituan versus Ikot Local Government Council. Citation is also provided. The notorious case of CBN and Ibilo, citation provided. It is worthy of note that the fact that an employer is a creation of statute does not elevate his employment to one with statutory flavor. See the case of Para State Judicial Service Commission and others versus Tolani, citation provided. The case of PACN versus Ofoilo, citation is provided. The case of Audu and Petroleum Equalization Fund Management Board citation is also captured. It is tried that before a contract of employment can be said to have statutory flavor, the employer must be a body set up by the Constitution or statute, and the statute or regulations made pursuant to the Constitution or principal statute or law must make provision regulating the employment of the staff of the category of the employee concerned, especially in matter of discipline. See the case of K, that is Kwara State Judicial Service Commission and Tolani Supra. Section 5.1 of the Kogi State Agency for Community and Social Development Project Law 2009, hereinafter referred to as law, which set up the defendant clearly provide us, and I quote, "There is hereby established by the state a body to be called the Kogi State Agency for Community and Social Development, which shall be a body corporate with a perpetual succession and a common seal. It shall have power to sue and be sued in its corporate name. Subsection 2, the agency shall operate as a state parastatal, shall be autonomous. It shall be the administrative organ to serve as a coordinating resource base for small scale or micro project funding. The agency shall have a project governing board, which shall be in the policy making body, that will ensure that the agency operates within the provisions of its mandate in section 3 of this law. While section 14 of the law provides further those, and I quote, the board may, subject to the provisions of this law and in accordance with the operations manual, make prescriptions with respect to recruitment, promotion, dismissal, and disciplinary control of staff of the agency. And this includes A, the qualifications required for appointment, B, method of appointment, including probation and confirmation, C, form of any agreement to be entered into between the agency and its employees, D, the terms and conditions of service, including staff salaries and allowances, and the grant of advances, the provision of quarters and related matters, E, the procedure and requirements for promotion, F, maintenance of discipline, including dismissal, termination of appointment, and G, such other matters relating to departmental procedures, duties, and responsibilities of employees as the committee considers can be best provided for by regulations, unquote. The provisions of the law reproduced above are easy to comprehend and require no special aid to interpret. From the above provisions, specifically the provision of section 5 highlighted supra, it shows clearly that the defendant's the creation of statute. Section 14 above gives the board, which is a supervisory body, the power to make prescriptions on the terms and conditions of service, the procedure for promotion, maintenance of discipline, including dismissal, termination of appointment, and such other matters relating to departmental procedure, duties, and responsibilities of employees as the committee considers can be best provided for by regulation. Claimants bid paragraph 12 of the statement of fact pleaded the document titled, quote and unquote, Community and Social Development Project, CSDP 2019, that is Exhibit F. The defendant in its defense pleaded bid paragraph 15A of its statement of defense, the Staff Regulations and Condition of Service 2009. I am mindful of the submission of learned counsel for the defendant in his final written address, particularly paragraph 4.5, where he placed reliance on the revised staff regulation and condition of service for the Federal Project Support Unit and staff agencies different from what the Staff Regulation and Condition of Service 2009 averred and relied on by the defendant in paragraph 15A of his statement of defense. It is Homebook law that parties, including their counsel, are bound by their pleadings and are not allowed to set up a case or argue outside the ambit of their pleadings. See the case of Michael Idachaba and others versus University of Agri Makurdi, citation provided. The case of Bakari and Idigbe and others, citation provided. The case of Kubo and another versus Dixon and others, citation is also provided. It follows that an address by counsel, no matter how brilliant, will not scratch the surface in the apparent quest for a change of nature of the case. Thus, the submission of learned counsel for the defendant in paragraph 4.5 of the written address is discountenanced. In furtherance to the above, the defendant who would want this court to believe that what governs the employment was the Staff Regulation and Condition of Service 2009 as pleaded in paragraph 15A of his statement of defense, are not the one pleaded and tendered by the claimants, failed to tender a copy of the said staff regulations 2009, it pleaded. The law is settled that where a document is pleaded and not tendered, the paragraph of the relevant pleading will be deemed abandoned. In the case of Oba R.A. Oyediran of Igbola and Oba Alebiosu II and other citation captured, the Apex Court per Kutigi JSC, later CJ now of blessed memory, held entirely outdoors, and I quote, about the other letter pleaded in paragraph 10 of third respondent statement of defense, and which was not tendered, the law is simply that that paragraph of the pleading is deemed to have been abandoned, unquote. See also the case of Takwa versus Sheshi and another citation captured. The reason for this is not far-fetched, as the court cannot speculate on the content of document that is not placed before it. The court is not allowed to go outside the gamut of evidence before it to shop for materials upon which to use to decide a case before it. See the case of Lawan, Abdullahi, Bupa, Wasa, and others versus Tuksha, Shahe, Kara, and other citation captured. The case of Okparaji and Ohanu citation is equally captured. Thus, the said paragraph 15A of the statement of defense is thus deemed abandoned, I so find and hold. However, in determining the type of employment entered into by the parties in the suit, the law is long settled that for an employment to have statutory flavor, the condition of service must be provided for and protected by statute or regulations made pursuant to a statutory power, as stated earlier in this judgment. That is the rules and regulation which are claimed by employee to be part of the terms and condition of employment capable of giving a statutory flavor, and for it to be of protection, must have a statutory reinforcement and must be directly applicable to an employee and persons of his cadre. See the case of Idoniye, Obu, and NNPC citation captured. The case of Forishi and NGC Limited citation is equally provided. In the case of Kwara State Judicial Service Commission and Tolani Supra, the Apex Court held that an employment is said to have statutory flavor when the appointment and the termination of discipline of the employee is governed by statutory provision. In other words, where the contract of service is governed by provisions of statute, or where the condition of service are contained in a regulation derived from statutory provisions, as I've stated earlier, they invest the employee with a legal status higher than ordinary master servant. In the instant case, although the defendant is a creation of statute, by virtue of Section 5 of the law, Section 10 of the law vests the board with the approval of the donor agency to engage or employ such officers or employees as it may consider necessary for the proper and efficient conduct of the business of the agency upon such terms and conditions as to remuneration or otherwise as it may determine. Section 14 then goes further to give the board the power to make regulations with respect to recruitment, promotion, dismissal, and disciplinary control, but there is no evidence of record to evince that the board of a defendant agency exercises its powers under Section 14 of the law to make regulations on the conditions of service, discipline, and other related matters. More so, the conditions of service relied upon by the claimants herein in their pleadings is not one made by the board as provided for in Section 14 of the law. Thus, the said condition of service does not have statutory flavor. The only reasonable conclusion that can be made in this regard is that the claimant's employment is not one laced with statutes. I so find and hold. Of note is the fact that parties in their pleadings did not state that the employment of the claimant is governed by the civil service rules or that the claimants are public servants or officers. In actual fact, that may not be the case because by virtue of Section 5, subsection 2 of the law, the defendant shall operate as a state parastatal and shall be autonomous. It is tried that it is not a business of the court to set up a case for parties different from what they have set for themselves. This is because parties in courts are bound by the pleadings and issues raised in the pleadings of parties. Therefore, this court will confine itself to the issues as raised in the pleadings of the parties before it. It would have been a different thing if the claimant pleaded the applicability of the civil service rules to their employments. From the pleadings and the evidence on record, there's nothing to evince that the employment of the claimant is laid with statutory flavor. I so find and hold. Now, the law has become unshakable like the Rock of Gibraltar, that where terms of contract of employment are reduced into writing by way of terms and condition of employment, the employment relationship is undoubtedly one of master-servant. Relationship between the master and his servant or employer and his employee is a contractual one, and it is governed and regulated by the terms and condition of the contract between them. See the case of Momo and CBN citation captured. The case of NEPA and Adesaji citation is equally captured. The law is equally settled that the rights, obligations, and liabilities of parties to such a contract are to be determined on the basis of the terms and conditions to which they have freely and voluntarily agreed to govern and regulate the relationship between them. This is because the common law recognizes and protects the sanctity of contract as parties are also bound by their contract. So the case of old pensions and online citation capture. The duty of the court is to interpret the terms of contract to reflect the intention of parties and also give effect to same. See the case of Sahara Energy versus Oyibola citation is provided. As such, where the employer wishes to terminate employee's employment, he must do so in accordance with the contract entered into by parties. See the case of Organ and others versus Nigeria Liquefied Natural Gas Limited citation provided, and the notorious case of Lunget and First Bank of Nigeria citation is also provided. Claimant hearing had tendered the revised staff regulation and condition of service of 2019. By the case of Yadis Nigeria Limited and GNIC Limited citation captured, document speaks for itself. See also the case of Ibrahim and Abdallah citation is also provided. Allied to this is the elementary principle that when words used in a statute are clear, precise, unequivocal, and unambiguous, the ordinary meaning of the words should be ascribed to them. See the case of Adejuma and Agumagu citation captured. It is clear that the said revised staff regulation and condition of service 2019 was made applicable to federal and state agencies for community and social development, which includes the defendant agency. In the absence of any evidence to the contrary, it is my respectful view that it is the 2019 regulation that applies to the employment of the claimant, and thus will be considered in deciding on the rights of parties in this case. I so find and hold. I've gone through the evidence in this case with the finery of a tooth comb, and certain facts are deduced therefrom. Although the defendant pleaded query letters dated 12 June 2018 and 21st of June 2018 respectively, which were not tendered in this case. I can find from Exhibit A letters of indefinite suspension of the claimants, and Exhibit G, the letters of invitation to attend meeting with members of the board dated 28 August 2018, that the act complained of took place prior to the coming into force of the said Exhibit F. It is clear on the face of Exhibit F that it was made in January 2019. It is thus clear that Exhibit F is not applicable in this case in respect of the procedure followed prior to termination of the claimant's employment. The consequence of this is that there is no regulation made by the board prior to Exhibit F before the court on the applicable procedure for discipline of the staff of the defendant. It is equally clear on the face of Exhibit G, the letter of indefinite suspension dated 11 July 2018, that the purported suspension was done in line with the Kogi State Community and Social Development Agency staff regulations and condition of service 2009, section 3.2, paragraph C of the said document is not before this court, as stated earlier in this judgment. The defendant who would want this court to believe that the suspension of the claimants was done in line with the particular staff regulation and condition of service 2009, did not tender any such document before this court. It is even funny that learned counsel, on behalf of a defendant, in his final written address, particularly by paragraph 4.5 at page 3, placed reliance on the said revised staff regulation and condition of service for Federal Project Support Unit and state agencies herein referred to as Exhibit F, contrary to the pleadings of the defendant that it is a particular condition of service 2009 that applies. However, I am mindful of the fact that Exhibit F is dated January 2019, as I've stated earlier, and specifically at page 4 of the said document, it is stated that it shall take effect from 1st of January 2019. Thus, it cannot apply retrospectively to the suspension of the claimant which took place prior to its coming into effect. As such, Exhibit F is not applicable to every activity that took place before its coming into force. I so find and hold. The pertinent question at this stage is, what is the propriety or otherwise of the claimant's indefinite suspension without pay? In the absence of any applicable condition of service, even though there is no document showing the applicable, just a minute. Even though there is no document showing the applicable disciplinary procedure prior to termination, it is without doubt that an employer has the unfettered right to discipline its employee under the common law, which action includes suspension. See the case of Union Bank and Salahuddin citation provided. The case of My Fen versus Unijust Consultancy Limited citation is also provided. The law is of commonplace that suspension does not entail demolition of the rights of the employee. See the case of Folusho and Enterprise Bank Limited citation captured. The case of Bamishile, an NJC and others citation is also provided. It is only a suspension from the performance of the duties. The status of the claimants as staff within the period of their suspension preserve their entitlements unless stated otherwise in their terms of employment or condition of service. In the absence of any evidence to the contrary, the suspension of a claimant does not mean loss of their entitlements. This is in view of the decisions in the English cases of Hanley and Peers and Partner Limited citation captured. The case of Marshall and Midland Electric citation is equally captured, where it was held that employers cannot suspend without pay where there is no express or contractual right to do so. The rationale is that an employer in doing so has taken it upon itself to assess its own damages for the employee's misconduct at a sum which will be represented by the wages of the days the employee remains suspended. In the absence of any applicable regulations governing the activities that took place before the coming into force of Exhibit F as held supra, one may want to argue that the issuance of a query to the claimant is enough to satisfy the requirement of fair hearing. However, I find from the averments of the claimant v. paragraph 14 of their statement of facts that they were invited to appear before the committee set up by the defendant to investigate the matter, but they were not given any hearing, in support of which they tendered Exhibit G, letters dated 28 August 2018 addressed to each of the claimants. The defendant, in response to that paragraph, v. paragraph 15 of his statement of defense, did not answer specifically to the allegation of the claimants that they were not given any hearing. It is right that traverse in statements of defense, but answer specifically and meet the allegation in the statement of claim of facts headlong. See the case of Agbo and Agom citation provided, the case of Van Vliet, Trucks Nigeria Limited versus Amcong and another citation is equally provided. Claimants in support of their assertion testified on oath via their individual statement on oath, particularly by paragraphs 14 and 15 of the statement on oaths of both claimants, that they were invited twice by the board via text messages and letter but were not attended to at all, as they were not given opportunity to state their defense. While the text message is not before the court, Exhibit G, which are the letters of invitation, is before this court. Exhibit G clearly shows that the claimants were requested to appear before the board on the 30th of August 2018, stating that the invitation is in line with their individual indictment and they each shall be given opportunity to clear themselves of their alleged offenses. I've gone through the exhibit tendered by both parties in this case, and I can categorically say that there is nothing that shows that the claimants were allowed to defend themselves before the board as stated in Exhibit G. It's clear on the face of Exhibit D, a letter dated 26th of March 2019, written by the acting board chairman to the World Bank, particularly in paragraph 3, wherein it was stated thus, and I quote, "In defense to fair hearing, the officers were opportune to defend themselves by their responses to the audit query issued through the Office of the State Auditor General and presentation made to the board's technical ad hoc committee by the affected officers," unquote. The above contents of the captured document stated that the claimants were opportune to defend themselves through the query and the presentation by the affected officers to the ad hoc committee. There is nothing on record to show that the claimant made any presentation to the board or were allowed to speak at all. More so, the defendant did not state this in their pleadings that the claimants made any presentation before the board or that they were allowed to defend themselves as stated in the letters of invitation Exhibit G. It is worthy of note that paragraphs 11 and 12 of the statement on oath of DW 1 and 2 clearly state that the claimants were merely given query to which they gave no satisfactory reply, and as a result of which the board resolved to suspend the claimants. There was nothing in the statement on oath to evince that the claimants were even invited by the board, and that they were allowed to defend themselves before the board as stated in Exhibit G. I'm of a calm view, therefore, that though there is no document showing the applicable procedure as stated earlier in this judgment, however, once the defendant have adopted a particular procedure and thus subjected the claimants to physical appearance before the board, they ought to give them the opportunity to defend themselves before the board as stated in Exhibit G in order to satisfy the condition of fair hearing. In the absence of any evidence to the contrary, I find that the claimants were not given, in the absence of any evidence to the contrary that the claimants were given fair hearing before the board, I believe their assertions that they were not given fair hearing by the board in its meeting where they appeared. I've held that Exhibit G applies to the employment of the claimants in the absence of any other evidence to the contrary. I've equally held that the said exhibit is not, however, applicable to acts done prior to termination of claimant's employment for obvious reasons stated earlier. Termination of employment of a claimant via Exhibit B, letters dated 9 February 2019, with effect from 11 July 2018. It is clear that the termination of claimant's employment was after the coming into force of Exhibit F on the 1st of January 2019, as I've stated earlier. It then means that the termination of claimant's employment should be done in accordance with Exhibit F. More so, where it is clear on the face of Exhibit B, letters of termination, that the defendant took into consideration the revised staff regulation and condition of service as stipulated in Section 3.2, paragraph D, subparagraph 2 to 5, and in concurrence with the World Bank. It is worthy of note that paragraph 3.2, subparagraph D of Exhibit F, the revised staff regulation and condition of service for Federal Project Support Unit and state agencies governs determination. It's also obvious from Exhibit G, written by the chairman of the Board of Defendants, that the several portions of the revised staff regulations and condition of service referred to in paragraphs 4, 5, 6, and 7 tally with what is contained in Exhibit F herein. Thus, there is no doubt that the revised staff regulation and condition of service referred to in the letter of termination of the employment of the claimant is the one before this court as Exhibit F. More importantly, where learned counsel for the defendant equally placed reliance on this document as the regulation governing the employment in his final written address. I find without any form of equivocation from all said that it is Exhibit F that governs the termination of the claimant's employment as captured in their letter of termination. What then is the provision of the said revised staff regulation and condition of service as regards termination? Paragraph 3.2, subparagraph D, provides thus, and I quote, termination of appointment. 1. The appointment of a confirmed staff shall be terminated at any time by the FPSU/SA by giving 1 month written notice of payment of 1 month salary in lieu of notice subject to the concurrent of the World Bank. 2. The appointment of a management senior staff member may be terminated by OVP/BODSA subject to the concurrence of the World Bank. 3. A senior staff member shall be dismissed by the OVP/BODSA subject to the terms stipulated in the condition of service for termination. 4. The appointment of an employee shall be terminated on the grounds of gross negligence or misconduct, which makes his or her continued employment prejudicial to the proper working of the FPSU/SA. All cases ending in termination of appointment shall attract benefits equivalent to 1 month's salary only. If the termination comes after a period of suspension, the terminal benefits shall be effective from the date of suspension from duty. Appointment of a junior staff shall be terminated by the FPSU/SA management in line with conditions set out in the terms of appointment. And paragraph 7, in an event of government terminating the appointment of a staff without following due process before the expiration of the duration of contract, government shall pay all the entitlements of the staff for the remaining years of contract. Where government defaults, FPSU shall, with the approval of the World Bank, deduct the money at source and pay the affected staff, unquote. I find at page 6 of Exhibit F, meaning of acronyms used in the document. The list defines FPSU, SA, OVP, and BODSA thus. BODS, Board of Directors of State Agency. FPSU is the Federal Project Support Unit. OVP, Office of Vice President, and SA, State Agency. It is apparent from the above provision or procedure that the defendant as a state agency can terminate the employment of any of his staff for misconduct. However, where such staff is a senior or confirmed staff, such termination shall be done with the concurrence of the World Bank. And where the staff is a confirmed staff, he shall be given 1 month's salary in lieu of notice. The claimants herein had not pleaded that they are confirmed staff of the defendant. However, it is clear that as managers monitoring evaluation, manager, finance, and administration, respectively, they are senior staff. They are senior staff of the defendant. It is equally clear as seen in Exhibit K4, tendered by the defendant, that the defendant sought the occurrence of the World Bank before, the concurrence of the World Bank before terminating the appointment of the claimants. However, paragraph 3.2, subparagraph D, V of Exhibit F is to the effect that all cases ending in termination shall attract benefits of 1 month's salary only, and where termination comes after a period of suspension, the terminal benefits shall be effective from the date of suspension. It is also of note that this is equally repeated in paragraph 3.3V of Exhibit F. Applying the above to the case at hand, it means that the claimants herein ought to be paid terminal benefit equivalent to 1 month's salary since the termination of the employment came after a suspension. The terminal benefits shall be effective from the date of suspension. Claimant read paragraph 12 of their respective statement on oath, deposed that the defendant refused to pay their terminal benefit along with amounts standing to their benefits. It is worthy of note that the defendant read paragraph 15, subparagraph B of the statement of defense admitted that claimants are entitled to terminal benefits and which has been paid to them by the approval of the board. The defendant equally viewed paragraph 7 of Exhibit G, recognized the rights of the claimants to the terminal benefit under the condition of service. The defendant who won this court to find that the claimants have been paid terminal benefit of 1 month's salary according to their assertion in the statement of defense failed to lead any credible evidence in proof of the payment of the 1 month's salary as terminal benefit. Therefore, I believe the claimant's testimony in their statement on oath that they were not paid their terminal benefit as provided for in the condition of service in the absence of any evidence to the contrary. Claimants ought to be paid terminal benefit equivalent to 1 month's salary and salaries from the date of their suspension, which failure of the defendant to do, failing which the defendant has breached the condition of service and it's fatal to its case. I so find and hold. I am not unmindful here of the retrospective effect of termination of claimant's employment, which fact was pleaded with paragraph 9 of the statement of facts, a fact which the defendant did not deny at all in their statement of defense. The revised staff regulation and condition of service provides in paragraph 3.2, subparagraph D5, paragraph 3.3v, that where termination happens after suspension, 1 month terminal benefit payable shall be effective from the date of suspension. One may argue that this means that termination shall be effective from the date of suspension. In my view, the provision is only as regards the effective date of terminal benefit payable, where termination follows suspension. I did not state that, the law did not state that the termination itself will be effective on the date of suspension. Assuming that it is even interpreted to mean that termination will be effective from the date of suspension, and I'm afraid such will be struck down as being an unfair labor practice. This is because the effective date of a letter of termination is the date it was received or the date the notice of termination was brought to the knowledge of the employee. It is right that an employer cannot issue a letter of termination or dismissal to an employee bringing an end to his service with a backdating effect. So the case of Cosmas NRD versus National Air Care Center and another citation captured. The case of Akimbola and Ministry of FCT and another citation is also captured. And the case of Underwater Engineering Company Limited and another versus Dubefon citation is equally provided. Thus, termination or even suspension or dismissal can be with immediate effect or at a later date specified therein, but certainly not retrospectively. The first claimant, as seen in Exhibit B, received his letter of termination on the 21st of February 2019. Although there is no indication on Exhibit B, the letter of termination of the second claimant on when he received it. The letter is, however, dated 19 February 2019, which this court presumes to be the date he received it. Claimants are entitled to treat their employment still subsisting to the said dates. The appointment of the claimants herein was in fact existing up until the 21st of February 2019 and 19th of February 2019, respectively, the dates they were notified of their termination. I so find and hold. I've held that the claimants were not given fair hearing before the board as they were not allowed to defend themselves in breach of the rules of natural justice. I've also held that the claimants ought to be paid 1 month's salary each as their terminal benefit as laid down in the revised staff regulation and condition of service, which the defendant relied on in the letter of termination, and failure to pay them as stipulated is a breach of the revised staff regulation and condition of service. I've held also that the appointment of the claimant was in fact existing up until the 21st of February 2019 and 19th of February 2019, respectively, when they were notified of the termination of their appointments. In view of the foregoing, I find that termination of claimant's appointment is wrongful, will not be in accordance with due process. Therefore, relief succeeds. Claimant read paragraph 15 of the statement of fact revealed that in view of a non-compliance with the rules of natural justice and staff regulation and condition of service before termination of their appointment, they are entitled to the benefit of Rule 3(2), paragraph 7, which is to the effect that they should be paid their entitlement for the remaining years of their contract, which is June 2020. I have read through the provision of paragraph 3.2, paragraph D, sub 7 of the condition of service, and it provides thus, I quote, in the event of government terminating the appointment of a staff without following due process before the expiration of a duration, government shall pay all the entitlement of the staff for the remaining years of contract. Where government defaults, FPSU shall, with the approval of the World Bank, deduct the money at source and pay the affected staff, unquote. The defendant herein, an agent of Kogi State government, failed to follow due process when they did not allow the claimants defend themselves before the board at the disciplinary sitting held on 30th of August 2018, and when they failed to pay the claimants the required terminal benefit of 1 month's salary at termination of their respective appointment. Their appointment was equally wrongfully determined with retrospective effect. There is no doubt, therefore, that claimants are entitled to benefits. Just a minute. There is no doubt, therefore, that the claimants are entitled to the benefit of the above provisions. The claimant read paragraphs 15 and 16 of the statement of fact averred that they are entitled to be paid from March 2019 to June 2020, and their entitlement each is 443,000 naira multiplied by 16 months, which equals 550, multiplied by 16 months, and also 550,000 multiplied by 16 months, which equals 8.8 million naira each as the reviewed salary. It is worthy of note that the claimants herein did not tender their pay slip or statement of account to evince that their actual salary is 445,000 naira or 550,000 naira each. Neither did they tender any evidence in proof of the purported review salary. Although this court finds that they are entitled to the benefits of paragraph 3.2, subparagraph D and 7 of Exhibit F, there is, however, no evidence to substantiate the amount they are claiming in Relief B or in the alternative Relief C. Does this court find that Relief B succeeds only to the extent that the claimants are entitled to be paid their respective salaries from the month of March 2019 to when their contract will expire in June 2020. I so find and hold. For the avoidance of doubt and for the reasons earlier given, I declare and order as follows. 1, that the termination of claimant appointment by the defendant was not in accordance with due process. 2, that their suspension without pay is wrongful. 3, that the backdating of their termination is wrongful. And 4, that claimants are entitled to be paid their terminal benefit from the time of their suspension till their contract is terminated in June 2020. Parties in this case are to bear their respective costs. Judgment is accordingly entered.
My Lord, we are most grateful to this erudite judgment. And our prayer is that God in heaven will continue to uplift you and grant you more wisdom. And for all the industry put to make this judgment. It's a judgment that some of us junior will learn more of it. I've learned so many things today. My Lord, God bless you. God will increase you and God will keep your life. You go more than this in Jesus' name. We are grateful, my Lord.
Thank you. Parties may obtain copies. Clean copies will be sent to parties. Very well.
We are grateful, my Lord.
So I rise from Lokoja.
We are grateful. Hey, Baba, this is tears of joy. Baba, I don't used to see people tears.